Welcome to S&C's podcast series, S&C Critical Insights. I'm Tony Lewis, a partner in S&C's litigation group and co-head of our national security practice. With me today are Sergio Galvis, who heads S&C's Latin America practice, Inosi Nyatta, co-head of the firm's project finance group, and Eric Kadel, who is co-head of the firm's foreign investment and trade regulation and economic sanctions and financial crime groups and national security practice. Thank you for joining us today. Today we'll be discussing what U.S. companies thinking about investing in other perhaps more politically sensitive areas should consider, especially in light of the new Treasury regulations that prohibit certain outbound investments in sensitive technologies. Cross-border investments and acquisitions can often implicate both regulatory complexity as well as political risk. And those aspects are more in focus when the investment involves technologies or commodities that are viewed as strategic or sensitive by any of the jurisdictions involved. We'll talk some today about semiconductors as an example of sensitive technology, and we'll be talking about some issues that can arise from the perspective of the US government when investing in China or countries that have significant ties with China. We're using these specific examples to illustrate what companies should consider in potential transactions generally. First, we'll define and discuss political risk. Then we'll talk about how the US government is addressing its concerns about outbound investments in semiconductors, and we'll touch on United States screening of inbound investment. We'll also talk about enforcement of those outbound and inbound investment rules, as well as broader enforcement considerations for cross-border investments in strategic technology. And finally, we'll conclude with a few takeaways about how investors should think about these issues in connection with these investments. One thing investors need to keep in mind in cross-border investments is the political risk that might come with those investments. Sergio, could you talk about what that means?
Of course. Thank you, Tony. It's great to be here with you and with Eric and Inosi. When it comes to political risk, it operates at many levels. It's multi-layered. It's a little bit like an artichoke where there are layers and layers. But for purposes of today's discussion, let's think of political risk at two levels. One, at the macro level. Now, what might fall into the category of political risk for a company, for an investor making an investment into a particular jurisdiction? Well, macro risk would be things like the host country's overall political and economic stability, the predictability of its legal system, and the application of rule of law within that legal system, as well as its overall policies toward foreign investors. And an issue that often manifests itself in emerging markets are questions of currency stability and free convertibility, transferability, exchange controls. Now, what does that mean? It could mean things like corruption issues that can affect contracting, a lack of effective remedies in local courts, in some cases, political violence. I already mentioned the risk of exchange controls in certain circumstances, or related to that, input restrictions that could limit the ability of an investor to actually bring in the goods that are necessary to get, say, the project going, or to the extent you're dependent on government contracts or elements of government contracts, the risk of breach of contract. There is another macro risk, which is kind of more traditional. You see it less, but still nonetheless is there, which is the possibility of expropriation, nationalization, or creeping expropriation with an increase in taxes, costs to the level where it becomes confiscatory. So that's kind of overall a sampling, if you will, of what some might think of as macro risk. And there are obviously micro level political risks, which are events or activities that relate specifically to the project at hand. Take, for example, a company that opens a plant abroad because it considers the particular jurisdiction to be one that is cost effective. Say it has a lower energy cost than other potential jurisdictions or labor costs. But then, to the extent that the country ends up altering the energy regulations such that energy shortages develop, the opportunity to have taken advantage of lower energy costs for their operations may disappear. Or say, for example, labor laws change and labor becomes more expensive. So these are kind of pseudo-economic, but ultimately often affected by political developments. And I should caution to add, Tony, that I mentioned earlier emerging markets, but it's pretty obvious from the range of political risks that have identified that these may very well manifest themselves in highly mature economies as well, which are not immune, if you will, from political developments that have a direct event in foreign investment. We're seeing some of that in the United States today. Semiconductors in particular, as you know, are viewed by the US government as crucial to protecting US national security, and not only US national security, but really protecting the ability of free trade to flourish in an open manner among countries committed to free trade. There's also a national defense element. These are potentially significant parts of advanced military systems. An example of the role of semiconductors in the area of national defense and military deployment can be seen in the context of the battlefield in Ukraine, where even with not overly sophisticated weapons, there's a critical role of the availability of semiconductors to supply the battlefield. The other issue, of course, is after the pandemic era supply chain disruptions that we saw, the US government has been taking steps to insulate semiconductor development from future interruption. Again, supply chain issues, some are logistical, some are economic, but some are very much in the realm of political risk. Also, as the United States geopolitical competition with the People's Republic of China continues to rise, the US has focused on protecting its competitiveness in semiconductors against China's pursuit of technological advantage. Therefore, if you're a business looking to invest in semiconductor needs, you will need to contemplate the wide range of not only regular political risk, as I was saying, host country political and economic stability, a country's history of expropriation, things like labor and energy that I mentioned earlier, but also specific political risk associated with the sensitivity of the product. And we've obviously focused so far, Tony, on semiconductors, but we're seeing this arise in other areas, including in base metals, as copper has become so central to the EV revolution. Copper's an area where, as you know, we've been involved in developing many, many significant copper projects, and then critical minerals more generally.
Great. Thank you so much for that, Sergio. Aside from doing due diligence before an investment to assess geopolitical issues and the relations of the investor's home country with the host country, Inosi, how else can these political risks manifest?
Thanks, Tony, and good to speak to you today. Sergio described micro-level risks, and in addition to sort of figuring out the scope of that risk, there are a number of relationships that are important to look at to determine the extent of those risks for a particular investment. And so if you have a host country that is misaligned with the interests of the investor, or that may be under the sphere of influence of a country that's misaligned with the investor, there are a number of relationships to think about in identifying the scope of that political risk and how one might deal with it. So let's take a hypothetical investment in a company in China. And that company is occupied in some position that's somewhere along the line of design and production of the supply chain of semiconductors. So one of the components that goes into a semiconductor comes from this company in China, and there's interest in making an investment in that company. So there are a number of areas where strategic commodities or technologies might be in play, and there are a number of countries that may be involved in analyzing that risk that we have to look at. Let's break that down into a number of components. First, you'd want to look at the overall commercial and political relationship between the host country and the host country of the investment and the host country of the investor. And let's say the investor is from the US, right? On the one hand, the US and China in this situation have intense geopolitical competition, particularly for technological superiority, as we've heard. Whereas on the other hand, China is one of the US's most significant commercial partners. And so the implications of that relationship in the long run, right, not just at the stage where the investment is being made, but potentially how it would play out in the long run, is something to consider in determining the risk of that investment. Secondly, it's important to examine the relationship between the host country and the industry that is being invested in. And that relationship is often going to be more significant where there's strategic technology or commodities at play. Semiconductors is one, as Sergio mentioned, critical minerals is another that we've seen have these issues play out. So again, looking at China, the semiconductor industry is known to be intertwined with the government. As of a few years ago, according to some estimates, 43% of registered capital, so that's roughly 51 billion based on that information, in the Chinese semiconductor industry is directly or indirectly owned or controlled by the Chinese government. And so investments in Chinese companies may risk having assets in those companies, like IP, diverted for government or military use. And this, again, is something to think about, not just at the point of time of the investment, but for the course of that investment and how it may play out in the future as an investor owning a share or interest in that company, how it would affect your investment in the long run. Thirdly, the availability of legal remedies and protections should be considered. Investors should be aware that in exercising their rights, they can be subject to protracted and costly proceedings with no guaranteed outcome. The US and China, for example, do not have a bilateral investment treaty or a BIT. And so the protections that a US investor may have, for example, would need to be explicit in the contracts. And even when they are explicit, there's a question of where they're enforceable and how long it will take to enforce them. And once you have a remedy, what you can do with that remedy in order to get the outcome that you anticipated up front. It's also important to think about the reverse scenario. We've just been talking about investments into a country like China, but in many cases, there are investments into a country like the US. And in particular, in the current environment, there's a lot of focus on who investors might be and who might control those investors in thinking about that investment. The US National Counterintelligence and Security Center and other government agencies have recently put out guidance for emerging technology companies and the security and competitive risks presented by investments made by foreign threat actors into those investments in the US. The guidance cites examples of how this risk has manifested through transfer of sensitive technology to threat actors through investments. There has been an example of certain companies in China who've offered investments in US and European companies only to back out of the investment after accessing their sensitive technology during due diligence. There was a UK company, for example, that agreed to be acquired by a company in China, began to transfer its technology to the acquirer in exchange for a portion of the sales price. And before the acquisition closed, the acquiring company backed out of the acquisition, but had access to that information. The guidance that's been provided cites a number of factors that companies can consider when evaluating risk, which include the complexity of the ownership chain, the use of intermediaries as an investing party, investments by US partnerships with foreign limited partners who are active in the partnership, intrusive requests related to sensitive data, or opportunism in seeking out struggling firms who may be pressured into transferring their technology in exchange for capital. And of course, political risk is only one type of risk to consider as part of an investment. So this is one of many factors that investors would consider, and other customary risks, commercial risk, technology risk, would also need to be considered by an investor or a company that is seeking investment, and with the help of experienced advisors to analyze those risks.
Thanks so much for that, Sergio and Inosi. Eric, looking at the outbound part of the equation, from a U.S. perspective, what kinds of things might the U.S. government be concerned about in screening outbound investments? What do the recent Treasury rules mean for U.S. companies looking to invest abroad?
Thanks, Tony. Let me start with proposed rules from the Treasury Department. In June, the U.S. Treasury Department proposed a rule which most likely will be finalized later this year. Public comments were due in August, so there's no guarantee that it'll be done by the end of the year, but there is some time for the Treasury Department to review the public comments and take account of them and issue final rules before the end of the year. And that proposal from the Treasury Department fleshed out an executive order that was issued by President Biden last August, directing the creation of an outbound investment screening regime. And it also follows on to an advance notice of proposed rulemaking issued in August of 2023 to accompany that executive order. The advance notice of proposed rulemaking really fleshed out a lot of the bones of the proposal, but there were comments given to that advance notice, and those comments were taken into consideration and addressed in coming up with this proposed rule. How does this operate? Well, we could do an entire podcast on this particular proposed rule. I'll keep it as simple as possible for purposes of this discussion. But sort of broadly speaking, what the proposed rule will do is it will identify countries of concern. And for now, as proposed, there's only one, it's China, but along with the Special Administrative Region of Hong Kong and the Special Administrative Region of Macau. And those countries of concern are identified because they are said to be exploiting or have the ability to exploit certain U.S. outbound investments, principally in sensitive technologies and products that are critical for the military, intelligence, surveillance, or cyber-enabled capabilities of such countries. The U.S. government has indicated its concern that Chinese government-controlled companies will be in a position to use American investment in sensitive technologies against the United States, as Sergio and Inosi had alluded to earlier. And certain technologies like semiconductors could be incorporated into military or surveillance instruments that can be directly deployed against the U.S. or its interests. Another way to think about this, or the concerns that motivate this, is that the Chinese or other countries of concern, as may be identified in the future, could effectively free ride on U.S. investment by appropriating the technologies, both in terms of advancing their technological capabilities in a way that they don't currently have on their own, and also in terms of receiving the value of investment without actually making the capital investment themselves and putting their capital at risk. This new outbound investment regime will, in some cases, prohibit and in some cases require Americans to report outbound investments in countries of concern involving the covered national security technologies and products, which in the proposed rule includes semiconductors, microelectronics, quantum information technologies, and artificial intelligence. When it's prohibited, Americans would not be allowed to acquire equity interests, participate in debt financings that are convertible to equity or that afford particular rights to lenders, engage in greenfield investments, greenfield being those investments where there's a brand new facility being developed, either facilities or operations. Greenfield meaning nothing existed beforehand, or participate in other corporate expansions and joint ventures in the specific industries in the countries of concern. The notification requirement would apply to any entity that's majority owned by persons of a country of concern, and certain exceptions would apply. Exempted transactions include, for example, publicly traded securities that are issued by an investment company like a mutual fund, some limited partner investments involving venture capital and private equity. Generally speaking, sort of more typically passive investments that aren't particularly substantial. You may think of it that way. The proposed rules also would cover transactions by controlled foreign entities of a U.S. person in some situations. So if there's a controlled subsidiary that's operating outside the United States, it may also be subject to these rules. Under these new rules, companies that are looking to invest abroad would be required to perform a certain standard of due diligence called the knowledge standard prior to investing. The U.S. investor must determine whether a transaction is a prohibited transaction, a notifiable transaction, or not covered under the proposed rule, and the standard by which the U.S. person's knowledge of the relevant facts and circumstances is assessed is an important aspect of the rule. Proposed rule defines the knowledge standard to mean that if a U.S. person or company knew or could have known a fact or circumstance through reasonable and diligent inquiry, the person or company could be held responsible for violations of the new rules. It's also worth noting that the proposed rule's definition of knowledge as actual knowledge that a fact or circumstance exists or is substantially certain to occur, or an awareness at the time of the transaction of a high probability of a fact or circumstance's future occurrence, or reason to know of a fact or circumstance's existence, is consistent with other terms, in particular, in this case, consistent with the definition of knowledge that's found in the export administration regulations that are administered by the Department of Commerce's Bureau of Industry and Security. While we've been talking about investments involving China and semiconductors as an example, I think it's worth noting that if an American company really is looking to invest in a Chinese semiconductor company, it has to look very hard at whether doing so is possible. U.S. government is very concerned about making it easier for China to increase its market share in developing sensitive national security-related technology like semiconductors. And right now, the Biden administration is attempting to restrict American financing from aiding China in developing its own sensitive technologies that could be used for weapons tracking, government intelligence, and surveillance against the U.S. It's a very sensitive area that must be carefully analyzed.
Thanks, Eric. So although these outbound rules are new, there's an inbound investment component as well that could be in play. To use the United States regime, could you provide a brief overview and touch on some current trends?
Yeah, sure, Tony. Happy to do that. What you're talking about generally is referred to as the CFIUS process in the United States, or as the Foreign Direct Investment Review process outside of the United States. These are processes whereby home countries will review outside investment and seek to determine whether that outside investment is creating national security issues. In the United States, the Committee on Foreign Investment in the United States, or CFIUS, it was formally created in 1975, established by executive order of President Ford, and has undergone some revisions since that time, but it's really more or less fundamentally the same thing as it was then, an interagency group of executive branch departments that reviews transactions for impact on national security. The committee is chaired by Treasury and includes members of multiple executive branch departments, including the Defense Department, the Homeland Security Department, the State Department, the Department of Justice, and it has jurisdiction to review control transactions and then covered investments in a U.S. business for national security concerns. Historically, notifications were always voluntary, although CFIUS retained jurisdiction if you did not make the notice to come after your transaction, even if you had closed it and had been operating your acquired business for any number of years. But after a change in statutory law during the Trump administration, notifications now are sometimes mandatory. Most significantly, that happens when a critical technology business is the target of foreign investment, or in certain transactions involving a critical infrastructure business or a sensitive personal data business where a foreign government is going to receive a substantial interest in a U.S. business involving either critical technology, critical infrastructure, or sensitive personal data. Otherwise, the notification regime is still voluntary. And very simply described, there's two paths that you can take now to give a notification to CFIUS. One is meant to be a simplified process. That's called the declarations process. And the declaration is intended to be reviewed by CFIUS over a 30-day period. In the formal notification, more fulsome process, More information is provided about the transaction upfront. CFIUS has 45 days to do a review. It may extend their review into an investigation period for another 45 days, which itself can be extended in extraordinary circumstances. And if all works well, the transaction will either be cleared at the end of that period or potentially referred to the president for decision. And the president, upon referral, has 15 days to act. There are ways that that period can get extended, but it's probably not worth getting into it for this particular recording. I will flag that in addition to sort of the national security issues that would come straight to mind, like a defense company or a entity that's providing significant amounts of products and services to the U.S. government, President Biden issued an executive order in September 22 that highlighted 5 additional factors for CFIUS to look at in addition to these traditional national security factors. The executive order calls for heightened consideration of supply chain disruption, potential threats to U.S. technological leadership, possible cybersecurity risks, and risks to Americans' private data that go beyond the sensitive personal data that's already covered in the existing definition of covered investment. The 5th factor in that executive order is a little bit more of a way to stop a foreign investor from sort of creeping into a national security risk, or maybe said a better way, prevent a foreign investor from mitigating or avoiding national security interest concerns by engaging in a series of transactions as opposed to one big transaction. And this factor asks CFIUS to look at aggregate industry investment trends and look at the context in which investments are taking place. If there's been a large number of similar investments by the foreign investor, then continued investment that may be viewed in isolation, don't have national security concerns, viewed in context, could have national security concerns. Historically, the CFIUS process resulted in very few blocked transactions. Transactions definitely could be mitigated. If there's a national security risk, there might be a national security agreement or some other agreement with the U.S. government to address the risk. It also was possible that parties could identify that a transaction was running up against some heavy headwinds and potentially abandon a transaction and not force a presidential decision. But I'd say in recent years, maybe the last 8 to 10, it's been more frequent that we see presidential decisions coming into play. President Trump was engaged in a number of these. You've probably seen reporting recently about President Biden standing ready to block an investment into U.S. steel, although that case is still ongoing. And there was an order from President Biden in May that did stop a Chinese crypto firm called Mine One from acquiring real estate under a different section of the CFIUS rules relating to real property acquisitions to be used as the crypto mining facility because it was within a mile of the Warren Air Force Base. So overall, in sum, we've seen the U.S. government identifying national security issues in a broader range of transactions and being more aggressive in mitigating and sometimes blocking a transaction that presents these issues.
Great. Thank you for that overview, Eric. Now, we've been talking about some of the rules that apply to both outbound and inbound U.S. investment. What kind of repercussions are U.S. companies looking at for violating any of these rules? Are they really enforced?
Yeah, so under the new proposed rules, obviously they're still to be finalized, but as proposed, they will be subject to the penalties that are available under the International Emergency Economic Powers Act, or IEPA. What this means is that you could face, for violations, civil penalties up to the greater of $368,136. This amount adjusts over time, and that's why we've got this odd number now, or twice the amount of the transaction that led to the violation, Criminal penalties could include a fine of up to $1 million, or if the violator is a natural person, 20 years in prison or both. Knowing in a willful cover-up or falsification or misleading the government can be fined or imprisoned up to 5 years. And the Treasury Department would have the ability, like it does under CFIUS, to effectively block or require the unwinding of an investment that violates the terms of the outbound investment rules. On the inbound investment side, where CFIUS reviews foreign investment, CFIUS, of course, can seek to negotiate mitigation agreements, but penalties can be imposed in 3 different circumstances: either a failure to file a mandatory CFIUS notification or declaration at least 30 days prior to the transaction completion date, non-compliance with mitigation agreements that have been entered into in connection with a previous transaction, or misstatements, omissions, or falsehoods that are in documents provided to CFIUS. But aside from running afoul of the outbound and inbound investment rules, I think there's a broader enforcement environment in play that people really need to understand, and in particular, where strategic technology is involved. And Tony, maybe you could tell us a little bit about that.
Of course. Thanks, Eric. As background, there are 3 agencies that are particularly relevant. The National Security Division of the Department of Justice, DOJ, is responsible for the criminal prosecution of sanctions and export violations. The Department of Commerce, Bureau of Industry and Security, or BIS, administers export controls. And the Office of Foreign Assets Controls, or OFAC, another office of the Department of Treasury, administers sanctions programs. Each of these agencies has been active in enforcement and in encouraging companies to self-report potential violations. Last year, NSD hired a chief counsel for corporate enforcement and increased its rank significantly. Also last year, BIS levied its largest penalty ever against Seagate for violating export controls by sending hard disk drives to Huawei, a company on BIS's entity list. And just last week, BIS announced its first chief of corporate enforcement. And OFAC has continued to impose sanctions aimed at preventing sensitive technology from aiding Russia's ability to prosecute the war in Ukraine. These agencies have put out joint guidance and pursued joint enforcement actions, like the $508 million settlement with British American Tobacco for violating sanctions on North Korea that was resolved with DOJ NSD and with OFAC. Businesses, therefore, need to be vigilant about possible national security risks in their outbound investments. DOJ, BIS, and OFAC all have voluntary self-disclosure policies that could help companies reduce or even eliminate fines or, in the case of individuals, prison time for violations of sanctions, export controls, and other national security laws. These policies are meant to incentivize businesses to disclose potential violations when they are first discovered. Each of these agencies' policies differ a bit, but in general, if a company makes voluntary self-disclosures of potential criminal violations, fully cooperates with the government, and it takes timely and appropriate remedial steps, and doesn't have other aggravating factors, government agencies will be more lenient than they otherwise might be. In June of this year, NSD announced its first declination to prosecute a corporation, a subsidiary of Merck, under the new voluntary disclosure guidelines. In this case, an employee had sent some of the company's controlled substances to China. The company had made a timely, voluntary self-disclosure to NSD long before the company had completed its own internal investigation, and was very cooperative in finding the perpetrators of the wrongdoing. In these situations, the national security threat constituted by the wrongdoing is also a factor, and DOJ decided that the threat wasn't so high in this case, and with no aggravating factors cited, NSD decided that it did not need to prosecute the Merck subsidiary. When thinking about investments and acquisitions, DOJ's recent guidance on self-reporting potential violations of various types, including Foreign Corrupt Practices Act issues, discovered at acquisition targets, is important to consider. Under that new safe harbor policy, if a company acquires another and discovers potential violations, they generally must be reported within 6 months and remediated within 1 year of closing. Those timelines will, of course, be difficult to meet in complex mergers with lengthy integration processes. But thorough diligence to identify potential violations pre or post acquisition quickly will best position the company to address them and potential regulatory or enforcement consequences. Separately, in connection with enforcement issues as to investments in strategic technology, last month, CFIUS fined a German telecom company $60 million for failing to prevent and report access to sensitive data in accordance with a national security agreement that was required as a condition of an acquisition in 2020. CFIUS has sharply increased the number and amounts of penalties it has levied in the last 2 years and made more details public. And we've seen investigations related to potential violations of those national security agreements that are reached in order to accommodate CFIUS's concerns. One last question for each of you. Overall, what should U.S. companies be thinking about when they want to engage in transactions with semiconductor companies or strategic technology generally?
Tony, as we've been discussing during this podcast, it's important to recognize political risk and try and minimize it as part of the investment. Minimizing it completely may not be possible, and there may be ways to mitigate the risk that is being taken on. There are tools that can be used for this. Political risk insurance is one. Third-party financing, including financing from governmental entities or other players who are able to absorb the political risk. And various other structures can be used to provide remedies to investors to help mitigate political risk. Investors could also involve a local partner, which needs to be analyzed carefully, of course, to determine that that is an appropriate partner to have for the type of investment. But having the appropriate local partner can also help mitigate the risk that a host government would take action that's adverse to its own citizens or business interests that are local. Ultimately, it may not be possible to fully insulate against political risk, and this needs to be taken into account in analyzing the investment. Investments in the semiconductor space are particularly difficult in current times due to the multifaceted and evolving nature of the political risks involved and have to be analyzed quite carefully.
That's great. I agree 100% with that. Let me just add a couple of thoughts that supplement what Inosi was saying. One is, we've been talking about, Tony, and focusing on U.S. companies as foreign investors, but this applies really to foreign investors regardless of where they originate from. And European companies, Latin American companies, Japanese and other companies will be facing the same issues and considerations. So that's one thing. Second thing, to supplement what Inosi was saying, is, as I think you gathered from this conversation, there is no one-size-fits-all manner of managing and addressing political risk. It's very, very fact and circumstance specific. So let's take the example of local partners. Inosi has highlighted important benefits of having a local partner under the right circumstance. At the same time, local partners may not be ideal partners. For example, if the local partner was selected in part because of close association, and I'm not talking here about corruption, but just general close orientation and association with a particular government, but then there's a change in politics. So as folks go into these judgments about political risk management, they have to assume that they're managing not only for the political risks that are in front of them that day, but how those circumstances might evolve. Financing partners, and Inosi referred to that, that's excellent because often you can have multilateral lenders, the IFC and others. You can have export credit agencies from different countries that have programs to support the supply of goods or the import of goods, and they can provide a range of relationships at the nation-to-nation level that can help to protect projects from suffering consequences of political risk. Understanding the macroeconomic conditions going into the investment, particularly on issues of currency that I mentioned earlier, it's very important not only to be able to have political stability, but also to have economic stability and currency stability. And then maybe the last factor I would mention, and this is something, Inosi, that you and I have talked about a lot, is thinking quite hard about how to be a responsible corporate citizen. And there are a couple of elements to that. One is you have a code of ethics, a code of conduct. You go into certain environments where the perception might be that business is done in a different way than in accordance with your code of conduct. Well, it's very important to not check your values at the door. In other words, your principles, your values that inform responsible corporate citizenship, you should carry around the world as you pursue foreign investments. Second, more specifically, think about the local environment in particular and the local needs. So applying your best practices, code of conduct, values, and thinking about how to best apply in the local setting. Be very aware of community relations and how your presence might affect the broader community and the reception that that community will have to your presence. As always, focus on practicing good labor practices, good environmental practices, and the like. And then lastly, look for ways in which you can shed political risk. We touched on it a little bit earlier, but there's a developing market, both at the multilateral and bilateral level, public level, but also in the private market, a developing practice of political risk insurance. And there are a number, in particular, in the private market, there are a number of insurance providers for political risk where they provide a very viable product to incorporate into your investment decision.
Well, as we discussed earlier, the proposed outbound investment rules about specific technologies, including semiconductors, apply to investments involving that technology, and they're separate from restrictions on exporting the technology itself. When companies are considering investments in sensitive technologies or with China, they need to include national security concerns as a significant component of their due diligence. Finally, on traditional inbound investment review, the CFIUS process, U.S. companies that are looking to do a transaction with a foreign investor do need to be vigilant about CFIUS notification obligations and its areas of recent focus. CFIUS, as you explained, has real power to mitigate transactions and even block transactions even after closing if you don't go through the notification process. And that can be highly disruptive to a business. You also, as the selling company or the investee company, need to be concerned about whether a mandatory filing applies, because the mandatory filing, if it does apply, is an obligation of both the investor and the investee. And in particular, when filing, need to be very conscious of the requirement to provide information to CFIUS that is fully correct and not misleading, so that you don't venture into a situation where you might face enforcement for providing incomplete or inaccurate information.
Thanks very much, Sergio, Inosi, and Eric, for being here today and for having a great discussion. And thank you for listening to S&C Critical Insights. For more information about national security and our practice, please visit us on the web at www.solcrom.com.